a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
So many people ringing in all ready to get some legal advice, but I've still got a couple of lines free. 1300 222 774 is the number if you would like David Whiting to dispense some free and fair and independent legal advice. David Whiting, good morning.
Good morning, Virginia.
Homework?
Yes, I had one piece of homework and one amplification. The homework was Paul from Box Hill. Paul had been, his company had been taken over. He'd been offered a new job, which was at the same pay and conditions, but his view was it was substantially less in terms of scope and seniority. Mm-hmm. The answer would be that I think the landlord has fulfilled, not the landlord, the business owner has fulfilled his obligations. And so what Paul wanted to do was to be able to take the redundancy a few months later. Answer was, I'm sorry, Paul, because there was a takeover of business, there was you don't have the right to redundancy in those circumstances, particularly because you've taken the pay and conditions.
Right.
That's the first one. The second one was Helen from, and this is in the nature of a correction/amplification. Helen rang from Caulfield, and her issue was that her landlord had given her a notice to vacate by a text message. And put simply, the question was, is it possible to give a notice to vacate by text message? And the short answer is yes, because it constitutes writing. But there are a whole series of things that need to be included in a notice to vacate, including the section under the Residential Tenancies Act that you're relying on, and you have to have the right number of days or more. Otherwise, it's not a valid notice, and it's as if it's never been sent. But and the problem was that the landlord was listening. And the landlord recognised the...
the conversation on our little radio station.
Yes. Okay. So, well, all listeners are good listeners, aren't they, Virginia? So from his point of view, his problem's going to be that if he tries to press on the basis of the notice that he's already served, he's required to get a order for possession from VCAT before he can bring the tenancy to an end.
Okay.
And then when he tries to do that, he'll be trying on the basis of a non-compliant notice. So he starts again.
All right.
So I would suggest there be some negotiations.
Yes. Okay.
Yep.
And we'll get it right next time, Dave.
Indeed.
That's
No,
right.
he will, or the landlord will, of whatever gender.
Yes, indeed. Now, also, just a clarification, Fiona McAllister was with us just before, the Mayor of the Yarra Ranges Council, and she just wanted to clarify something that she said on this program just before the news as well. When she said Council didn't support the logging of native timber, she was talking specifically about old growth forests, and she says she misspoke and said they didn't support the logging of native timber. Of course, that is a big part of the industry up there in her neck of the woods.
But normally plantation timber.
Exactly. It's native timber, but it's planted native timber, which is then planted to be cut down. So plantation timber, she was speaking specifically about the objection to old growth forests, a very different thing. Now, there are still people in the area that don't like either of those two aspects of logging, but that's not what was under discussion, so happy to clarify that. 1300 222 774 is the number, and first up is Beryl in Malvern East. Good morning.
Good morning, Virginia and David. My husband bought land in 1953-54, and it was 83-foot frontage onto the street.
Yes.
Which is quite all right.
In East Malvern, that sounds fantastic, Beryl.
Yes.
Yes.
So what happened, but at the back of the block, it's, say, 60-foot wide. So when he bought the land, he asked if he could have a little extension of land at the side there to...
Square it off.
23 feet. Yes, I'm impressed, Beryl.
To even up the block.
Yes.
So he asked the council about it, and the council said that the land below was put aside for road making.
Yes.
And there was a 5-year plan on it. And to just straighten the block as he wanted it.
To square it off, yes.
And then that to use the land, plant a couple of trees and grass it and that, and leave it for 5 years, just use it and see how things worked out.
And here we are, 60 years later.
Here we are. We've been here for 64 years. And I'm wondering if that little bit of extra land there now could be
if the land belongs to council, the Limitation of Actions Act was amended some 20 years ago to say that you couldn't have an adverse possession claim against a council.
Oh, right.
So you're 20 years too late.
Oh, fancy.
Had you rung 30 years ago, we would have been just fine, but there are no longer capable of running adverse possession claims against council. So you need to find out who really owns it.
Yes.
And then make a decision as to whether you have, because sometimes the land isn't actually in council's name.
Right.
So I would be looking at that first. If you like, the council keeps a register of its assets, and if this land is on its register, then you have no claim against it, Beryl.
Oh, right.
But I think a title search is worthwhile.
Right. Well, this piece of land, it's only available to the tenants now. There's a way put through there now for cyclists and walkers. It's the only way out of this estate, other than one-way drive in.
Doesn't make any difference, Beryl.
Oh, right.
It's just if it belongs to the council, the game is up.
Oh, righto then. Thanks, David.
Thank you.
Good on
Bye-bye.
you. Thanks so much. Great that you called in. Happy we could help. Andrew in Frankston, what's happening?
Yeah, hi. I was driving to Warrnambool with my fiancée about 3 weeks ago, and we drove around a corner and it was a 100 zone, and we saw the police sirens, so we slowed down, but then we hit a cow in the middle of the road.
Yes.
So we pulled over, told the police, and that we ended up finding out whose farm it was. The police contacted them the next day, gave us their details, then we swapped insurance details, and the car's since been written off. But their insurance is saying, well, they haven't made a decision yet, but they're leaning towards, unless the fence was broken or the gate was left open, they're not liable. If the cow just jumped over the fence, they aren't going to pay.
Andrew, it's the argument that everybody gets one opportunity to stuff something up. So the question will really be whether or not the farm owner has done enough to expect that his cattle will be contained. So
the farmer... Oh, sorry, go.
No. So that is the essence of the argument. If you're able to establish that the cow has jumped the fence before, then I'm in your favour. But in the event that you can't, then the question is really whether or not the fences were adequate. And I know they weren't in this instance. And as I understand it, sometimes animals learn to jump and then keep jumping.
So the cow was housed 3 paddocks away, and this is what the daughter or the niece told us on the phone, and that it constantly is jumping fences.
Then there's your evidence that it's the farm owner's problem.
Okay, so that'll work in our favour.
Absolutely, because look, if you went back 50 or 60 years, the expectation was that it was essentially cattle had the right to roam. The law got changed, and it's now up to the owner of the cattle to contain the cattle.
Okay.
And yes,
quick one. Because it was a calf, and the cows in the paddock that were along the highway where this one wasn't supposed to be housed, they were like 6 times the size, like a lot bigger. Would the fences require different, gaps depending on the size of the animal?
I find that every issue that I discuss in relation to farm activities gets a whole series of abusive phone calls, Andrew, so don't ask me about animal husbandry or fencing. What we've got is evidence that the cow was a regular escaper, and that's the evidence you want.
So good luck with that. Gary in Bundoora, where are you? There you are. Good morning.
Good morning. Hello, how are you?
Good. Well, thank you.
Hello?
Fire away, Gary.
Go ahead.
Yeah, sorry. How do I know if I had a friend 15 years ago and he said, I'm going to leave you something in my will, and the gentleman's passed on and I've lost touch with him, how do I know, how do I explain it? How do you
find out if he left you money?
Yeah, and I've lost touch with him.
Well, yeah, but he died, so somebody's keeping you in the loop.
Sorry, I missed that, sorry.
You know he's died, so somebody's keeping you in the loop.
Oh, well, even if I didn't know that he died sort of thing. You know,
Gary, here's the process. Well, first of all, you've got any idea who the solicitor for the estate is or who he might have left his money to?
I don't think Gary's sure that he's dead yet.
Yeah, no, not really, no.
Oh,
No.
wow. Okay. Gary, I'm really impressed. I'm glad you're not my friend.
Yeah, no, it's just a common question. Like I've been
Gary,
thinking...
supremecourt.vic.gov.au, you'll be able to see if an application has been lodged for a grant of probate of your friend's will.
Yep.
And that will be a start. You'll need his full name and you'll need the year of death, but you can search through a few years. And if it's there, you can then track it down and either go to public records and get a copy of the will, or work out who the executor or the solicitor is and talk to them.
Gary, if you find out that he's still alive, would you like to be his friend again, or are you just after the money?
Definitely. No, he was a good friend. He was a very good friend.
Okay, well, that's nice to know.
If only you'd framed it, Gary, on the basis that you're trying to find out if a dear friend had died. Yes.
Exactly.
It's all the question you ask, isn't it?
Elaine in Hawthorne, good morning to you.
Good morning, David and Virginia. I've got a very similar question to the previous question. I've driven past a construction site in Kew East a few weekends ago, and directly in front of the construction site, I hit a nail and it punctured my tyre, and a brand new tyre, and it was written off. I wanted to know if I can actually claim the Builder for damages.
If you can prove that the nail came from the construction site on the balance of probabilities, yes, you can.
How do I go about doing that?
Well, do you still have a nail?
No.
So how do you know it was a nail from the building site?
It was directly in front of it.
Yeah, I'm sorry, that doesn't quite get you there, particularly if it's a busy street or there are other activities going on in the street. If you knew what the nail was and you were able to establish that they were using those nails on that building site, then I would have thought you'd have a fair prospect of making a claim. But if all you know was, you've had the tyre either repaired or replaced and you know it was a nail, but that's all you know, I wouldn't be wasting your money. You'd be spending more on lawyers than you did on a tyre, Elaine.
Fair enough.
Yep.
All right, good luck.
Thank you so much.
Good luck with replacing the tyres, and maybe there might be something on insurance, who knows. Rick in Gisborne, good morning.
Good morning, David and Virginia. We did not become aware that we were living in a dependent persons unit or a dependent relative unit until there was a fire on the property.
So were you renting a building on someone else's property, are you, Rick?
No, we own the building.
But you own the building? Is it on someone else's land?
No, we live in a duplex situation with another family.
Yes.
My question is, should we have been told by the conveyancing solicitor when we bought this property that it was a dependent relative unit?
Well, there would be nothing shown on the land title. A dependent relative unit to me is like a granny flat or a supplementary residence in the back of someone's property. But what Rick is describing is being a duplex, so it may have been constructed on the basis, look, here's the bigger house for the family and here's the side bit for the others. I would probably, Rick, start by going to Macedon Ranges Council, getting a copy of the planning permit that allowed the construction, because there may be some restrictions under the planning permit for the property that affects you.
There are, I understand, there are restrictions.
Right.
And
how long ago did you buy, Rick?
About 10 years.
Yeah, that could be the problem. What I would also then consider is whether or not you need to make an application again to the Shire, which is Macedon Ranges, in relation to a further planning permit which would allow you to live in an independent living unit rather than a dependent unit.
Is that complicated to do?
Part of the issue, Virginia, will be whether or not there needs to be fire rating, whether it needs to be separately plumbed, separate electricity supply. There's a whole series of issues that need to get looked at. But the starting point is to look at the original planning permit and see what's in and not in.
Rick, can you get your hands on that, do you think?
Yeah, probably. Just on David's point, though, the fire destroyed the adjoining property, and that has to be totally rebuilt. Our property was damaged by smoke and water and has been partially rebuilt, so we've been dealing with the council through all of that process.
Yep.
And I think your reference to firewalls and such would be taken care of.
Okay. So I think what I would be looking at getting a copy of the planning permit and then sitting down with a planner and seeing what we can and can't do.
All right, good luck, and we hope that goes well. Mick in Sunshine, how can we help?
Morning, Bruce. My GP is retiring and selling his practice. Now, I think his only assets are our records.
Yes.
He says my record belongs to him because he took the notes. I say they're mine because I gave him the notes for his benefit only.
The rules are a bit strange, Nick. You are entitled to everything that he's got for you or got on you. There's legislation relating to medical records and who gets to keep them and who doesn't. The doctor that my daughter has been going to is retired from practice, and he simply distributed all these records to the patients and those people who he was they chose to go to. You're entitled to a copy of all of your records, Nick, and you can take them wherever you like.
But the doctor's not entitled to sell those records to somebody else.
That's the nature of the goodwill. I've now bought Dr. X's practice, and I'm now open for business. No, you don't buy the patients. You don't buy the patients.
But the records are the patients. The records are just the
paper
version of the patients.
No, the records are of the patient.
Yes, of course,
but they're not. And the records, the patient is entitled to a copy of the records, but they're also the doctor's records for the purpose of providing care and assistance.
Yes, but if Mick has not allowed that doctor to hand on his personal records to another doctor, they can't just be handed on.
Then I think that what Nick would say is, give me the records, don't pass them on.
Is that what you want to say, Mick?
Yeah, I'll just have a quiet word. Everything should be fine. Okay. Beautiful, thank you.
And I'll just make sure for next week that you have the right to say, no, you can't pass them on. All right?
Terrific.
Thanks very much, Nick.
That'll be terrific. Thank you. Richard in Warburton, hello.
Hi, how you going?
Good, thanks.
I just wanted to ask if my father's died.
Sorry.
He's got a legal will which I've cited. But I'm not sure. I know it's been signed in front of a solicitor and done legally, but I don't think he was in a fit state of mind to have been making those decisions at the time that he did that. I don't know what grounds you've got for checking things out like that, but
it is possible to challenge a will on the basis of lack of testamentary capacity, that he didn't have the capacity to make a will on the day at the time the will was signed.
Yeah.
Yep.
Okay,
so that would normally involve have you got a copy of the death certificate, Richard?
Yes.
And was there anything in the illnesses that he suffered at the time he died which would indicate lack of capacity? So every now and then you'll find a death certificate that says dementia 5 years, and the will is 3 years old, and at that stage you get a requisition from the probate office saying prove that he knew what he's doing when he did it.
Okay. So how would I go about doing that?
Well, you've got a copy of the death certificate.
Yeah.
You might choose to write to his doctor and ask whether he had any concerns. You might choose to write to the lawyer. What exactly is the issue? Would it affect what you consider to be an appropriate distribution of the estate, Richard?
Oh yeah, definitely. Basically, what's happened is he's remarried. And left everything
to the new partner.
Yeah, nothing to his children. If you actually knew the circumstances, you'd find it actually quite shocking that he would do that.
Then the other issue, Richard, is that
was at the time that he did it. He was in an alcohol rehab and had nearly died the night before, and was rescued apparently by or found,
Then Richard, I would be looking at lack of testamentary capacity, and what I'd be suggesting is that you and your siblings look at it as a single issue that you all have the same interest in.
Okay, good luck with that, Richard. It sounds complicated and tricky to do, and also very painful process to go through as well. Lots of texts coming in, David, about our conversation about the GP records. My mum's GP sold her history to a mob in Sydney, and she had to pay $90 to then have it re-released to her new GP. This as well, the medical record created by the doctor is his property, says Trish. But also this on text, no one pays for medical records, and the suggestion that Nick just contact the Victorian Health Ombudsman and they'll sort it out. Any views on any of that?
Well, I'd agree with the last one. Again, there's a particular piece of legislation relating to retention of medical records and who's entitled to them or not. And there have been a series of glorious VCAT cases over whether you're required to pay or not pay and who they can be released to.
Yeah, who they can be released to is the real issue here, I reckon. I mean,
well,
that's
let's say
shocking.
Let's say that I'm a doctor and I retire from practice. What do I do with my records?
Safely destroy them? Offer them?
Oh, no, that's worse.
Offer to return them to the copies to the patients, I guess.
A former patient, someone who I haven't seen for 5 years. What effort do I need to put into finding them?
What does the law say?
Well, can we make that the first question for next week?
What does the law say about medical records? We're all going. When I say we are all going to go off and do our homework, what I mean by that is he's going to go off and do homework. Lisa in Kew, what's happening in your world?
Oh, hi. My neighbour has demolished his house and is building a new one. Didn't even actually tell me before he moved out and the building commenced. But one thing that was shown on the plans that he submitted was that the boundary was not in the correct place and the fence was over my side. So he has some of my land. He's never actually spoken to me about this.
Yes.
And they marked it all out. The builders have gone and removed a post that actually showed where the accurate fence line was.
No, sorry. Hang on. I'm stuck, Lisa. The fence was too far on your side.
Yes. But there was post. It had leaned over.
So how much are we talking about?
About 30 centimetres.
Okay. Yep, worth an argument. In Kew, 10 inches is worth an argument. Yep.
On a plot of 226 metres, it makes a difference.
Yes.
And there was posts at the back, and they clearly identified it was significantly
So
out
I
of
would,
whack.
and Lisa, I would be taking some photographs that would show where the hole was and what the measurements were. And then the question then arises as to whether you've lost that land by adverse possession or not.
He's only been there for 5 years.
Now, how long has the fence been there, Lisa? How long has the fence been there?
Probably 20.
Then you've probably lost it by adverse possession.
But in the past, the guy who was there, I had access to it because it wasn't closed at the back. So I could get through there because I had quite a good relationship, and the post was still there that showed it. So he's not responded to the Dispute Resolution Centre.
Well, Lisa, what I would be doing is probably going, what I would start today is find out the person who your neighbour bought from.
Oh, I know. Right? He's deceased.
Well, then from his estate, you want to buy whatever rights of adverse possession he or his estate may have had in the property. So you want to get back that 30 centimetres, and if you were to do that, then he's only got 5 years adverse possession and he needs 15.
All right.
All right?
Okay.
Good luck.
How do I do that? I mean, I was quite friendly with the guys.
supremecourt.vic.gov.au and search his name, find out who the executor was, and then what you do is you see if you can buy back those rights from the estate.
All right. Good luck. We hope that goes well because, as you say, yes, 10 inches in Kew.
Is it worth a lot?
Worth a mile.
Yes.
All right. Bit of homework for next week, and will be the full bottle of medical records next week as well. David Whiting, thank you very much as ever.